so that we'll put it on both the Comms Council and the ANZA websites, so that people have access to it and can share it with teams that weren't able to attend. So Lindsay, I'll hand over to you.
Thank you, Paul. Really appreciate collaborating on this. We're really pleased to join, or ANZA's really pleased to join with the Comms Council in the seminar. At the end of the day, clients and agencies have a common interest in complying with the new Privacy Act. And the two organisations worked together in submitting to the government as they were reviewing the draft bill. So this is really the culmination of the work we did together. And that's the kind of thing that the Comms Council and ANZA do on a regular basis on legislation and regulation that may affect you, our respective members, be they clients or agencies. But you aren't here, obviously, to listen to Paul and myself. So let's I'd like to introduce our guest this afternoon, Anthony Drake. With more than 25 years of experience, Anthony provides advice and counsel to a wide range of major corporates, to the New Zealand government and various local government agencies, SOEs, as well as individuals and private clients. Now, as well as being an employment law specialist, he has a particular focus and interest in privacy law and data protection. And he's a regular presenter and commentator on privacy law topics, as well as being a contributing editor to Thomson Reuters and OneTrust data guidance on New Zealand law and data protection in the privacy area. Reading his bio, I was interested to see Anthony was a founding member of the Serious Fraud Office. So I know it's unlikely, but should the SFO ever come knocking on your door, perhaps you now know who to call. But more seriously, welcome, Anthony. And on behalf of all our attendees this afternoon, we're really looking forward to your presentation. Over to you.
Right. Thanks, Lindsay, and thanks, Paul, for the introduction. We all know that changes come at a time where data protection landscape is changing rapidly, both in New Zealand and globally. Cyber security and data protection are now some of the biggest issues facing local and international businesses. And with the ever-increasing risk of cyber threats, and just look at the large uptick in recent months and during the global COVID-19 pandemic, it's huge. Media attention given to data breaches and the increased risk of reputational harm, and international regulators starting to wield their big sticks, particularly under the GDPR legislation. There's never been a better time for us to pay attention to looking after our data. And that's exactly what we're going to talk to today. We all know personal data is like oil, it powers today. And in my view, it's very profitable business. It's just like the old fossil fuels who energized those past years. It's digital gold. And consumers, their information is extracted from them often, with them knowing very, very little about what's going to be collected, who's going to get to look at it, what it's worth. The internet might set one of those biggest privacy nightmares that you come across, but don't throw your smartphone out just yet. Personal data is a pretty vague umbrella, and it helps to unpack some of that, and that's what I want to talk about with this slide. Personal data includes things like your name, your surname, your home address, an email address, a personal one, an identification card number. Your location data is important in today's world. For example, the location data function on your mobile phone. Many of you don't realise that you can be tracked. Even the swipe card that you have when you enter your office has a RFID inserted in it, and you can be tracked between even floors. The systems are incredibly sophisticated. Personal data might also include things like your IP address, a cookie ID, and advertising details for you personally. We all know things like your hospital record, your doctor's records, things that have unique identifiers are all personal. Now, what's not? Well, things that are publicly available, things like a company registration number, an email address such as info@company.com won't be personal data. Anonymized data, and I'm going to come on to some of that a little bit later in the presentation with tech businesses selling data to you. Right, what are we going to look at today? I want to approach this, as Paul said, in three areas. Some of you have been in touch with me in recent weeks to say, hey, can you cover off some of the basics just for our business? And so that's the first part of this presentation. The second part, managing the use of your clients' personal information, then finally managing customer data. So from an agency point of view, and I'm going to use the word agency, meaning an organisation here, not your business as agencies. So you shouldn't use or disclose personal information you hold, unless that's why you've collected the information originally and you have the individual's permission, or you have grounds to rely upon in one of the exceptions in the Act. So that's that sort of first-hand principle thing. Because the purpose of advertising is generally to share information publicly and widely, if something goes wrong, for example, and you use someone's photo inappropriately or even mistakenly, the potential consequences can be serious and difficult to mitigate, particularly if the information's online. So such as collecting collecting information for the purposes of advertising or publicity, or getting consent to use that information for information you already hold, you should be very clear about exactly how you intend to use information, where it is to be used, when, and for how long. Now, we're going to get into some of that sort of detail very shortly, because I'm going to take you through the privacy principles. As a rule of thumb, it's always helpful to work on a no surprises basis. In other words, the person shouldn't be surprised with the way in which you end up using their information. So in this slide, I've set out what the principles are. Under the new Act, which comes into force on the 1st of December this year, we have 12 principles. Some have been amended, and the 12th principle is a new one. So interestingly, in the new Act, just as counting up the sections, the new Act has 216 new sections. The old Act had 133. Not sure what that means, but obviously there's more things for us to look at and consider. And a lot of it comes down to compliance. So the first principles, these are all about the collection. Principles 1, 2, and 3 govern the collection of personal information. And this includes why personal information may be collected, where it may be collected from, what you can tell an individual, and how it is collected. As I mentioned, an agency in this context refers to an organisation. Principle 1 is for the lawful purpose in connection with the function or activity of the agency. The Act clarifies that businesses should not collect identifying information if it's not necessary. So what the Act is trying to do is you only collect what information is necessary for the function or activity of your business. Pretty straightforward there. Principle 2, there is no change from the previous Act. This is about the source of the information, and best to collect the information directly from an individual concerned. We're going to come on to collection of information later. Principle 3, what agencies should tell people when collecting their information. Well, this is to ensure the individual is aware that the information has been collected, the purpose of the collection, and the intended recipients of the information, how it's going to be used. the name and address of the agency collecting, and the right to correct any information. Principle 4, agencies should collect information by a lawful means. Now, what does that mean? Well, simply fairly and not being intrusive. So it's pretty straightforward. You can't surreptitiously collect information on people. Principle 5 governs the way personal information is stored, and it's designed to protect personal information held by an organisation, business or agency from unauthorised use and disclosure. It requires you to take reasonable steps against loss, access, misuse, use, modification, disclosure, or other use. Again, not terribly difficult and not much change there. Principle 6 from the old Act has been modified. Principle 6 gives individuals the right to access information held about them by an organisation, business or agency. There are new grounds for accessing requests, such as under the Health Information Privacy Code. So that's probably more helpful than not to have some clarity around that. Principle 7, that gives individuals the right to correct information held about them by an organisation, business or agency. And employees and other people are entitled to look at their information or request to look at their information and have it corrected if it's wrong. Accurate before use, Principle 8. Principles 8, 9, 10 and 11 place restrictions on how organisations and businesses and agencies can use or disclose personal information. These include ensuring information is accurate and up to date and that it isn't improperly disclosed. In Principle 8, as I've said in this slide, you can't use information that's not accurate, not up to date. It's as simple as that. The important point here is the focus is on the steps taken, not ultimately the accuracy of the information. Retention of information, Principle 9. Well, this simply states an organisation shouldn't keep personal information for longer than is required for the purpose it was collected. This intersects with quite a number of other pieces of legislation, and some of you will be familiar with them. In the employment arena, things like keeping wage and time records, the 7 years, Holidays Act 6 years. So there's other legislation requirements which intersect with this. But this principle is, well, if for example, you advertise for candidates for a role, the question becomes, should you retain their CVs following the selection of a successful candidate? So all the other unsuccessful candidates, in principle, you should be destroying their CV unless you ask permission of those other unsuccessful candidates if they wouldn't mind you retaining their CV in case another role came up. That's just an example of how you deal with that issue. Principle 10, the purpose. Information obtained for one purpose should not be used for another purpose, i.e. what an agency can use personal information for. You can't retain information for the purposes of hiring somebody and then use it for a different purpose. There are some exceptions to this. If an individual authorises you to retain their CV, that's fine. The information will not identify the individual. That's fine. Court proceedings, we're not particularly concerned about that. Disclosure of information, Principle 11. When an agency can disclose personal information, well, there are limited circumstances, and they include directly related to the purpose of the collection, where the information is already publicly available, it's necessary for the maintenance of law or a threat to public safety. Not too controversial there, but provided you're collecting information for the purposes making it public, then that should in your industry be fine. Now, this is a new principle, disclosing information overseas. Organisations or businesses may only disclose personal information to an agency outside of New Zealand if the receiving agency or company is subject to similar safeguards to those in the Privacy Act. If jurisdiction is not similar to our protections under this new legislation, the individual must be fully informed that the information may not be adequately protected, and they must expressly authorise the disclosure to that overseas agency. So that's quite new. Cross-border data flows, again, part of that new Principle 12. The changes introduce restrictions on overseas disclosure of personal information. Unless the relevant individual has authorised the disclosure outside of New Zealand, as I said, the disclosing party will need to ensure that the information will be protected by the safeguards comparable to New Zealand's privacy laws before the transfer can occur. Examples of this can be achieved in some simple ways. If you have that situation, enter into a contractual arrangement with the recipient party overseas that they will protect the information, and those protections will be in compliance with the New Zealand Privacy Act. Or you can ensure that the recipient is subject to laws of another jurisdiction that provide comparable protection. Now, importantly, the transfer of personal information to an offshore data processor, e.g. a cloud storage provider, will usually not constitute an overseas disclosure. This is an important exception given that none of the other major public cloud service providers have data centres in New Zealand, although Microsoft, I understand, has announced some plans to start a centre in New Zealand soon. Of course, I mentioned the GDPR compliance, and that really is ensuring the recipient is subject to other laws, such as there is that general compliance with that legislation. Now, there are some other key changes in the Act. Mandatory data breach reporting regime will see New Zealand move a little closer to the international best practices standards. Under the new laws, any organisation that suffers a data breach that has caused or is likely to cause serious harm to an affected individual will be required to notify the Privacy Commissioner and the relevant individuals. The Privacy Act includes guidelines for assembling and assessing the likelihood of serious harm, and these include things like action taken to reduce the risk of harm following a breach, whether the personal information is of a sensitive nature, the nature of the harm that may be caused to the affected individual who obtained or could obtain the personal information as a result of the breach, and whether the personal information is protected by a security measure. Where there are some circumstances where individuals do not have to be notified. They're rare. I can envisage a situation where you may have personal data or personal information on your laptop and you accidentally leave it on a bus and it goes missing. Well, most of us today have protections on our laptop, so that's fine. But the question is whether you now need to report that as a data breach to the Privacy Commissioner. At this point in time, the answer to that is yes. I envisage that the Privacy Commissioner may change his views on that in the future if he gets hundreds of disclosures and reports each week. So when don't you have to report it? If, for example, reporting a breach would jeopardize your organization's security systems and they then become vulnerable. But again, as I said, that would be kind of rare in my view. regardless, you'd still have to report it, but there may be good reasons to delay reporting it through to the Commissioner on that basis. The Privacy Act now expressly states that it will apply to any actions taken by an overseas organisation in the course of carrying on business in New Zealand, regardless of where that information was collected or held, or where the person to whom the information relates is located. An organisation would be treated as carrying on the business in New Zealand, whether or not it has a physical presence here, charges for any goods or services, or makes a profit from the business here. So it's quite a wide extraterritorial scope. Where there's been a breach, if you're an individual, what can you do? Obviously, individuals can contact the agency directly, if it's your employer, to try and resolve your concerns first. They're entitled to make a complaint to the Privacy Commissioner's office, or if you have concerns about your online safety, or have you been the subject to a scam, you can contact NetSafe, ID Care, Cert New Zealand, and police if it's a ransom type situation. What else is new? This is interesting. The amendments give some limited additional powers to the Privacy Commissioner, such as the ability to issue compliance notices and demand release of personal information in certain circumstances. We mostly find that in the employment arena, where employees want access to their personal information, personnel files, those kinds of things, and there's resistance to provide that. However, controversially, the amendments don't go as far as fully aligning with the Privacy Act, with other highly publicised data protection laws such as the GDPR and the Californian CCPA. Most notably, the Privacy Commissioner does not have the ability to hand out massive fines like we see for privacy breaches in Europe or the USA. Individuals do not have the same right as data subjects in other countries, such as the right to be forgotten, which we see under GDPR, or the right to data portability. Whether this shortcoming will impact New Zealand's adequacy decision under the GDPR rules, or otherwise affect data flows between New Zealand and major trading partners, remains to be seen, but that's something to look out for. I've mentioned here also there are some new criminal offences. It's an offence to mislead people about access to your personal information or someone's personal information. It's an offence now to destroy personal information knowing that a request has been made. And as I've mentioned there, the fines are $10,000, which is very modest by comparison to the $1 million fines that we see under GDPR. Now, moving into sort of a slightly different area, we're moving into how your organisation looks at your data and who's watching you generally. Well, some people say that Facebook is snooping on you. Let's say, for example, you talk about a holiday to Fiji at home, and all of a sudden, and you may have noticed this, I certainly have, you get advertising holidays to Fiji. You might think that that's a bit strange. Facebook, of course, denies snooping, but it could use information about your level of wealth, your past holiday interests, the time of the year. For example, the ads come through during the winter period for winter getaways, and also your location. What might seem like is snooping can just be clever advertising. You'll probably also be aware that Google keeps tabs on what you're up to on its devices, apps and services, but you might not realise just how far its tracking reach extends into places you go to, the purchases that you make, and much more. It's amassing an extensive set of data. You can, of course, take control of what Google, Facebook, and any other person collects about you. And it's worth emphasising that there really is just two issues here. The amount of data that some of these organisations collects on you, which is a lot, and what they do with it. And Google would say that its data collection policies, for example, improve its services, helping you find a restaurant similar to the one that you recently went to. It also say that people disagree with that. But a lot of the data we're talking about here is generally only visible to you or used in a limited way to make ads relevant to you. And ultimately, the choice is either you trust Google or whoever to use all of this data responsibly, not use Google services at all, or you limit the information any of those services can gather about you. There is also the issue of targeted ads and things like that. Well, speaking in advertising speak, companies build ad profiles on you, and they're particularly interested in your demographics. We all know that. You can purchase details of people's age groups within bands, gender, income, location, followed by a whole host of other topics that some of these data tech businesses I think you might be interested in. Now, moving into another phase of this presentation, managing your own organisation's data. This is an area that some of you expressed some interest in. And how do you manage that? Well, with evolving technologies, more stringent compliant policies, as we're talking about today, and the need for data analytics and long-term data retention, these are all important factors that you must consider when attempting to manage your own organisation's data. There are two good reasons for this and why data planning has become a higher priority for today's organisations. Firstly, the sheer volume of data that we need to deal with each day has increasingly and exponentially grown, which needs managing. And secondly, the amount of time organisations are expected to store their data also for an increased period of time over recent years. More stringent compliance and regulatory policies have been introduced globally, and we've talked about some of those, requiring data to be retained for long periods of time now. So what's the answer here for you? Well, I recommend that you have defined policies for the collection and deletion of policies. How long are we going to keep information for? How are we going to store it? What are our security systems? And what if you're hacked? Well, we saw what happened to our stock exchange in recent weeks. It put them out of action for 5 critical days. And so these are all important things to ensure that you have the right security systems in place and your personal information is protected. I recommend that you have a plan. It's a theme I'm going to return to a little later. What about managing client and customer data? Or breaches or careless handling of private information may cost you dearly. Customers will lose confidence in you. Your brand and your reputation will take a hit. You can only collect personal information needed for business purposes, and you must not let it be leaked or misused, even accidentally. You should follow the same protocols as you do to protect all of your business systems and data. This means keeping any private information stored online safe from breaches or hackers. It also means doing whatever is reasonable in the circumstances to protect any paper files or documents. So how do you safeguard this information for your clients and customers? It depends on the sort of information you collect. The Privacy Act requires you to protect information in ways that are reasonable, which is what I've mentioned, given the circumstances. The more sensitive the information, the more measures that you'll need to put in place. But I do recommend that you have a personal data protection plan. You assess the risks of what we're going to be facing, and you put together a mapping process. As I've mentioned in this slide, you define the data collection and deletion policy the same as you would with your own information. And the policy you may want to think about is having a policy to assist clients and customers to fulfill their obligations under the Privacy Act. As I mentioned at the start, on the internet, what the personal data users give away for free is transformed into a precious commodity. We know businesses amass, analyse, buy and trade data. For example, the puppy photos you uploaded train machines to be smarter. The questions they ask uncover humanity's deepest prejudices, and their location histories tell investors which stores attract the most shoppers. Even the seemingly benign activities like staying at home and watching a movie generates mountains of information, a treasure trove if you like, to be scooped up later by all kinds of businesses and traded. Every day, hundreds of companies around the world are collecting information about you and some more intimate information about others. That information may then flow to researchers, hackers, law enforcement, even foreign nations, as well as plenty of companies trying to sell their stuff. All this information is collected on a wide spectrum of consent, of course. Sometimes the data is forked over knowingly, while other scenarios users might not understand that they're giving up anything at all. So there are a wide range of things that you need to think about. Often it's clear something has been collected, but the specifics are hidden from view or buried in hard to understand agreements. I've mentioned their first, second and third hand data. Most of you will be familiar with those concepts where you get data from customers directly or data sought from elsewhere. And then we have the cookies and also data analysts. I raise with you here some food for thought. Consider this: what happens when an investment company buys a controlling interest in a genealogical ancestry company and obtains your personal information, including, more importantly, your DNA profile? Well, that's exactly what's happened recently with Blackstone, who purchased Ancestry, where people had given up their personal data and even their DNA so that they could track their family trees. Where and what Blackstone might do with that data, that information, who knows? Too early to say. I've also mentioned Cambridge Analytica. Many of you will be familiar with that story. Cambridge, of course, was a British political consulting firm that combined misappropriation of digital assets, data mining, data brokerage, data analysts with strategic communication during an electoral process. It was used in the last American election. And that data was leaked in early 2018, where millions of Facebook users' personal data was harvested without their consent. Again, very interesting. Now, more of the commercialization of data. Many of you will use information provided by tech businesses, and I've just set out half a dozen very valid reasons why you might want to use that. But what must you do? Well, only collect what you need for your business purposes, e.g. the name and contact details. Tell people how, when and why you are collecting their information. This includes using cookies on your website with an explanatory reason why. Tell people what will happen if they don't give you their personal information. Keep their personal information safe. Only use it if it's reasonably sure it's accurate and up to date, and let people see the information and correct any mistakes. Some of the things that you need to think about, the do nots. Do not ask for information that you don't need. That's principle one. Let the personal information be leaked, hacked, or found in any other way. Do not keep information longer than you need it or are legally required to keep it. Or don't pass on someone's details without their permission. Now, how the Act is enforced, if you break these rules that we've talked about, even accidentally, a customer may make a complaint to the Privacy Act, a Privacy Commissioner. We saw a couple of years ago a case that went through the Privacy Commissioner all the way through to the Human Rights Tribunal, where a lady mentioned her dismissal. She prepared a cake which had the words F off and her employer's name. And the upshot of that was that photo was posted on Facebook. There was a campaign by the employer to discredit her as a result of that, and the information was improperly used. That ex-employee was awarded $180,000 or thereabouts in damages. So you need to be really careful how you allow that sort of information to be used. Further on commercialisation of data, do tech businesses comply with the Act? I've simply put that as a question there for you to think about and ask them when you're purchasing data that you want to use. Do you need the consent of individuals? Well, we've talked about that under the principles. Many of you will be collecting or getting data that is anonymised. Largely, that's safe to use, so that shouldn't be a problem. Information based on unique identifiers, that can be problematic. You probably need consent for that. We're seeing less and less use of cookies today, but again, there are waivers in relation to the use of cookies and being up to date on that. What shouldn't you do? This is the regular disclaimer that you'll find, or an example of one, when people are reminded of cookies. We value your privacy. Well, you shouldn't use or disclose personal information you hold unless that's why you've collected it. You have generally the individual's permission, or you have grounds to rely on the exceptions listed in the Act, and you can't use it. Because the purpose of advertising generally is to share information, and I talked about that publicly and widely, when things go wrong, they can cause quite significant problems. So as such, you need to be careful when you're using personal information. My final thoughts, because I've used up most of my time, security is key of personal information. You now have obligations to notify the Privacy Commissioner if there has been a breach of privacy, or you've misplaced your iPhone or laptop or something like that. And then finally, you should review your policies and protocols of keeping information safe. Right, questions?
Thanks, Anthony. Anthony, any questions will be coming in down the bottom of your screen under chat there.
Yep.
I think I put a couple in earlier that just to kick things off.
Hi all, please note that if you would want to ask me a question, he's listed as Wynne Williams in the chat room. Okay. If a customer is no longer a customer, can you keep their information? The answer is no. You know, if they're no longer a customer, the purpose for which you had their information has gone. Another question, what would you consider good practice in terms of how often companies should review their privacy policies? I would think it should form part of your annual plan. It may be a small exercise just to check in that you're up to date. Another question, how do we know which countries have similar privacy rules under Privacy 12? Yeah, well, that's a good question. Those are the questions that you need to ask when sending your information. What are their privacy laws? Another question, does the new Privacy Act address market research data? Once de-identified, are these also supposed to be not kept longer than required or used for another purpose other than the original purpose? It doesn't specifically address market research data, but it is covered by that principle that you don't keep the information any longer than necessary. So if its purpose is spent, then you get rid of the data. Is it reasonable to run an online survey as a means to, whoops, it just flicked over, as a means of data collection? Yeah, provided you have the right disclosures to people, the purpose of why you're collecting the information, and they consent to it. I don't see that methodology is a problem at all. Do you have any advice on customer audiences on Facebook based on customer data that has not been collected for advertising purposes? Is it sufficiently safe to share data with Facebook, as Facebook claims it's hashed when uploaded? Well, that's a judgment issue in my view. Would I share personal data on Facebook? No, but a lot of people do. What do we need to consider in terms of overseas transfers to countries that are subject to government rights to access data? Yeah, that's a very interesting question. One I've come across, and government wants to access your information that you're going to send overseas. In jurisdictions like that, it may not be safe to send it, and you may think very, very carefully about that before you allow personal information to be sent overseas or used by an overseas entity. There's a question here. When you said be clear on how we use the data, is it sufficient to detail this in the terms and conditions the customer accepts? Yes, it is. A question here. If you are purchasing information from a third party, how liable are you for any breaches by the third party? Really depends on how serious the breach is, but the general principle will be no, you shouldn't be, but if you're using that information, then you'll fall within the privacy principles, if that kind of makes sense. Hopefully it does. Does Australia have comparable privacy laws? Yes, they do. Question, aside from reporting a breach, a leak in consumer data, do companies have any responsibility to address damages, spanning as far as impacts to mental health and or remedy the risk for other breaches before they continue to resume data collection? Not specifically. It would fall within your general employment obligations if an employee is saying, well, because I lost my information, or you lost my information, and that's damaged my reputation and mental health, then yes, there will be claims available to that employee, but whether you need to remedy that before you resume collection again is quite a different issue. Another question here, does the new Privacy Act address the use of first-party data or customer matches in partnership with advertising publishers? Well, it kind of does in general principle and the use of it. Just to confirm your comments, loss of our laptops. If a work laptop or an iPhone is lost, would this currently be a notifiable breach? The answer is yes. The risks are low, I would have thought, mostly because it's incredibly difficult to break into an iPhone or an iPad or most laptops, provided your laptops and things have security settings on them. Right, the questions keep coming. Does the Act Act specify plain language disclaimers and consent, or can the current 300-page tiny writing, slight exaggeration, still be used? You're speaking to a lawyer who more words than less is best. I think there's some work to be done for us to try and get disclaimers down a bit, but a 300-page tiny worded document might be a little bit over the top. But yeah, the Act doesn't specify plain language disclaimers, but New Zealand's tended to go that way. Overseas jurisdictions like the US are still cumbersome. Final question. Do the penalties under the Act apply to companies only or to individual employees as well, i.e. personal liability? No, they principally apply to companies, but I envisage in the future maybe it could also apply to employees. That's it, Lindsay.
Great, thanks Anthony, and a great set of questions everybody. I'm sure there'll be more coming through one way or another. We'll make sure you've all got Anthony's contact details should you require a one-on-one session. So just falls to me to wrap up. I think there's an easy response and say we actually dodged a little bullet, or that we were a little lucky that the Privacy Act isn't as onerous as it could have been, and certainly compared to what the draft bill was. And while that's true, I think that doesn't change the fact that this provides a really important opportunity for all businesses to take stock of the data they're collecting, why that is, and how they're managing it. And if I reflect on feedback I've had from out of Europe on GDPR, most businesses, while they found it onerous to actually put in place the steps to be compliant with GDPR, actually found it a really important exercise for their business to take stock of data. What is it they had, and why, for what purposes were being used, and actually to organise data in a much better way. And that I think everybody, or most companies who have been involved in that process, actually look back on and think, for their own purposes, that's been a positive step, and certainly from a social point of view, a societal perspective, it's also been important, because at the end of the day, public trust underpins everything we do as advertisers and marketers, and if we're not managing data well, and that becomes public, then we undermine that issue, that public trust, and that undermines our own objectives. So I really just challenge you all to take on the task as within your businesses to start thinking about data more seriously, about how what data you're collecting, the reasons for that, and how you're safeguarding your responsibilities under the new Act. And as Anthony said, I think to one of the questions, it's something you should be reviewing probably annually in terms of your data protection policies. So in conclusion, I'd just like to thank Anthony for presenting today. I'm sure you've all found it valuable. I'm sure you've also going away with further questions to consider, but the important thing is this has provided a stimulus for you to do that. So on behalf of the Comms Council and ANZA, thank you very much for attending, and I hope the rest of the week goes well. Thank you.
Thank you, everyone, and thanks Anthony, much appreciated.
Thanks.
Okay, bye.